here for their input to this committee. Just want to take a moment to set up a few numbers at FI High School in Texas League last week.
Good morning, 116.
Chairman Petrarca for remarks.
Thank you, Chairman. I too want to thank the testifiers of our 2 weeks of hearings a few weeks ago on gun violence. I thank the members for sharing their thoughts on this very important topic. I also thank the testifiers here today. This is obviously an issue that is very important to a number of people on all sides of this issue. I think we have to find a way to deal with what is happening in our communities and in our schools in an effective way, and also the rights of law-abiding gun owners. And hopefully we can work through that and consider all viewpoints and opinions, and maybe do something or not do something that makes sense for the people of Pennsylvania.
Thank you. Our first testifier this morning is Scott Fulcroft, Associate Professor of Philosophy and Legal Studies at Penn University. Scott. Good morning.
Good morning, folks. To have this hearing today, you're always welcome back, of course. Representative Marsico, I'm glad you, and welcome here on behalf of University President Eric Darr and Board of Directors also. I want me to convey their welcome to you. I teach courses in, obviously, based on my title, I teach courses in law and philosophy, but I think more importantly for this hearing, I teach a course that's required law, which starts with identity, sense of self, moves out to self and other relationships and empathy, moves out further to an individual's position in the community, what they can do for the community and what the community does for them, and then developing reasonable policy around this. It's entitled The Creative Mind, and this course is required of all freshmen, and it goes for the entire first year that they're here. It really is intended to help their critical thinking and information literacy skills. When we got to policy this spring, certainly we had a plan of which policies we were going to cover, but with the number of school shootings and with the folks who were the age of our freshman class being affected by this was obviously on the radar. And a lot of their responses were very emotional from both sides, which you've seen. Representative Marsico, I like the way you frame this from both sides, and obviously the critical thinking that you're using to narrow this down to what are the issues. You call the Santa Fe school a hardened target already, which is an issue that's on people's minds. Are they soft targets or hard targets? But when my students brought this up, I kind of took the leash off of what we were going to do this semester. And they wanted to do some research and present on this topic specifically. I said, go ahead. And the debate started very emotionally on both sides, whether they were pro-Second Amendment or whether they were pro-strict gun legislation. And so it started with, they're 18, 19 years old. Of course, they're going to start with very impassioned positions on this, but what they ended up with was a look at and I encourage this, let's look at science. This is a science and technology university. Let's look at the data. Let's do some research and look at where these issues are. And obviously you're already doing that. But I would encourage you to look at not just the data, whether it's neuropsychology or social sciences, scientific experts. And because the people who are coming to you often are those who have an agenda, who have a bias. But I've seen, I practiced law in this county for 20 years, and I've seen trial lawyers go out and find the experts in the world who can inform you and help guide you. And why not do that? Why not form a commission to go out and find these experts who will help you narrow these issues? When you have 320 million legal guns in this country, and you see how many are responsible, how many of those guns are in the hands of those responsible for these acts, it's statistically very tiny. And yet it impassions us because of the evil involved in it. that's a word that's not used so often nowadays because we don't, in today's scientific-minded world, we don't look at evil incarnate. But I asked my philosophy class one time to define evil, and they said, well, this is after a semester of thinking about it, doing some readings on it and whatnot. And they said, well, it really comes down to the intentional harm of the innocent. And you know, whether that be children or whether that be animals who can't protect themselves or whatever. And so I take that and I look at it, and that's really the difference between the dramatics such as this volcano we're looking at in Hawaii. It's really not going to affect that many people. Or the difference between something that, on a large scale, really does kill. If we were going to take away those kinds of threats, the automobile would have been banned a long time ago. But we still make efforts to carve out narrow safety exceptions to free speech, and in this case, perhaps the Second Amendment. And while it's important to protect the Second Amendment, it's also important for us to perhaps look at the science and data that would really help us narrow down why the folks who are doing this are doing what they're doing. And that's why I say look at the experts, the neuropsychologists. You're already looking at somebody, you know, you're saying that the shooter in Santa Fe did not have any kind of flags go up. I was speaking to a grade school administrator recently who said that when they identify issues with students, they have to go to the parents to have them released, just to sign a release, just to have them look at the student and to be evaluated, diagnosed, and treated. And if they don't sign off on that, because of the stigma, perhaps, of their child being labeled as having a mental health issue, then there's nothing the school administrator can do about it. And that kind of clear behavioral issue that led to this is also leading to their separation from their fellow students. And then we bring in the whole issue of bullying, which has come up in a lot of these school shootings. This is obviously a multi-pronged issue. It's not just related to firearms, it's related to mental health. And it's related to things I think science and data and research can help you with. I encourage you to do that, to look at that data, to go find the experts in this rather than just have folks come to you. There are many folks in this auditorium today who would like to come to you and give you all the statistics that they could. For instance, one of my students found the inverse correlation between legal gun ownership and gun violence. And I looked at the students who want some serious gun legislation. I said, how can you argue against this? And they said, we can't. But then I looked at them and the other side and I said, how can you argue against trying to do the hard research and work to go find the experts to tell you how can we craft some minimal exception to the Second Amendment that's actually going to make a difference? I mean, imagine a world where those who are in support of the Second Amendment actually want to look for this narrow exception to help the other side, to empathize with the other side, and those who want some kind of gun legislation to actually look at themselves and say, we need to keep this as narrow as possible because we understand what the other side is doing. Again, I keep reiterating, I'm going to end my remarks now, to look at the science of this. I have a colleague who's encouraged me to ask you to look for developing a culture of responsibility when it comes to firearms. You know, when parents, for whatever reason, are allowing their children to take their firearms to do something, there isn't that culture of responsibility. So, thank you for coming here, and if you have any questions.
Well, thank you. Questions, members? Commissioner Joswiak, a question?
Thank you. Good morning. And thanks for testimony. You hit on a subject that I think is important. You mentioned about it's not just a gun issue, it's a mental health issue. So as we've been hearing some of these hearings, I'm becoming of the opinion that the HIPAA rules today, that is an issue that prevents people who know somebody is disturbed or prevented from letting law enforcement know about it, unless they're going to absolutely say, I'm going to go out there and shoot somebody. So what do you think we can do with the HIPAA rules? Can we
In place that prevents us from developing policy that will help us to prevent these gun shootings? Yes, I think we should. If there's policy that keeps us from looking at those who may be a threat, I mean, the man who shot up the school in Florida, I mean, how many times have he been engaged with those who have been reporting him, with law enforcement? And I think at some point, especially after the fact, I mean, if somebody has committed an act, if somebody has engaged with the Secret Service and is on their radar and done some illegal act, perhaps that's where you carve it out, where you say, we need an exception here so that we can just open this up and study it. Study each of these people who have committed these crimes, these heinous crimes, and say, what's look at it?
Thank you,
Questions? Seeing none, well, thank you, Professor.
Thank you.
Appreciate your time. Next testifying is Shara Goodman, ceasefire PA.
Good morning. Thank you, Chairman Marsico, Chairman Petrarca, members of the committee for holding these hearings and the hearings in April. My name is Shara Goodman. I'm the Executive Director of Ceasefire PA. We are a statewide gun violence prevention organization. We work with mayors, police chiefs, faith leaders, community organizations, and individual Pennsylvanians to take a stand against gun violence. I submitted lengthy testimony, which I will not read, but I will hit on a couple of key points, if I may, and then take questions. I'd also like to say, and this may surprise some of the folks in the room, that despite what the professor said, I actually think you have called on many of the experts. Although I don't always agree with Mr. Prince and Mr. Stolfer, I hope that they would say the same, that we are experts all on this issue and can give you a lot of the data that you need. And some of the people that you have called today. I think between the hours of hearings you had in April and the hours you're taking today, you have good bills in front of you that accomplish what the chairman asked for, which is how can we address the issue of gun violence and gun accidents in Pennsylvania while respecting what is a robust right to bear arms in this state. You have several good bills that have been introduced by members of this committee, by your colleagues in the Senate and the House, and many of you have signed on. And so I think that we can achieve that. And I would urge you that we don't need another commission. You've had commissions, you've had hearings. It's time to look at these bills and take votes and send them to your colleagues in the House. So just for a little bit of context, in 2015 in Pennsylvania, there were 1,485 firearm deaths. 533 were homicides and 932 were suicides. I know that it came up in the April hearings that some people believe it's not fair or somehow misleading to include suicide deaths when we talk about gun violence. I actually disagree with that, and will tell you why. Guns are lethal, as you know, and suicides that are attempted by firearms are much more likely to be fatal than attempts by other means. Put simply, those who use firearms in suicide attempts have a much lower chance of survival. Approximately 85% of attempted firearm suicides result in death. Second, the accessibility of guns in the United States facilitates firearm suicide. And we know that easy access to a firearms in the home actually increase the risk factors for suicide. And the decision and the action of suicide are often impulsive. A quarter of survivors of suicide attempts report later that they made their attempt within 5 minutes of their decision to do so, half did so within 20 minutes, and 3/4 within an hour. So I firmly believe, as do many of my colleagues testifying today, that we need to account for those suicide deaths when we talk about gun violence in Pennsylvania. We also need to talk about domestic violence. We also need to talk about accidental shootings. We also need to talk about crime that plagues many of our men in Pennsylvania are much more likely to die by guns than women, and black and white men experience firearm deaths in very different ways. Middle-aged white men who live in rural and suburban areas in Pennsylvania are much more likely to die by firearm in suicide, while younger African-American men who live in our urban areas are much more likely to die in homicide. All of which is to say that we have a problem. As I said earlier, a very robust and strong right to bear arms. We have a system that does not require a license or registration prior to purchase. There's no waiting period prior to purchase. There's no training requirement to purchase. There's no limit on the number of firearms and the amount of ammunition you may purchase. We have open carry without a license, except in Philadelphia. There's a relatively permissive process for obtaining a concealed carry license. We have no child access prevention laws, no safe storage requirements. We don't require an owner to report if his or her gun goes missing, and we allow the private sale of long guns without a background check. There are gaps here that we could address to deal with and to reduce the level of gun violence and gun deaths we experience. There's some key policies that we outlined in our testimony that we urge you to look very strongly at and to vote out of this committee. The first is what's known as an emergency risk protection order. I believe it was introduced by member Todd Stevens and signed on by talking about this bill for a number of years. It's gotten a lot more attention since the Parkland shooting, and I believe that 3 states have actually enacted it since the Parkland shooting. This addresses part of the problem that you, Representative Joswiak, just asked about. What do you do when a mental health professional doesn't rise the level of mandatory reporting, but somebody knows that something is wrong, that somebody is in crisis? This creates a civil process, very much modeled on a temporary restraining order process in the domestic violence context, where somebody who would not be prohibited because of their mental health history could temporarily be blocked from getting a gun or temporarily have guns removed. We don't have anything like that right now. So right now in Pennsylvania, if your mental health history has risen to the level of an involuntary commitment or being declared incompetent, you lose your gun rights permanently. Now many of those people will never become a harm to themselves or others, and they've now lost their rights permanently. So you may be surprised to know, but Representative Stevens can tell you that Ceasefire PA has worked with him in the past on how do we get those rights restored. On the other hand, it's under-inclusive. What about the young man who comes back from college, having failed classes, having a bad romantic relationship, feels like everything is spinning out of control, but has never been to a therapist, has never been to a guidance counselor, has not been declared incompetent, but somebody knows something is wrong. And this person, there are guns in the home, or he can go buy a gun. He may be very much in danger to himself or others. I met a father in Allentown that this exact situation happened to. His young son came home, told his father he was in crisis. They made an appointment to go together to a therapist that afternoon. By the time the father got home from work, the young man had gone to a gun store, bought a handgun, and shot himself. You don't get a second chance. We could do something about that. The states that have enacted this law have found it works. Not only to prevent homicides or mass shootings or murder-suicides, but especially to prevent suicides. Connecticut has had a law in place like this for years. They allow law enforcement to do this. It has prevented suicide. I have a lot of data on that in my paper. If we can do something that works, that is proven to work, we should do that. And again, it is temporary. People can get their gun rights back, which is important. It is a right that we should not take away forever. People can get the help they need. People can get through a crisis and should be able to resume their normal life. I would encourage you to look at that bill. It has bipartisan support. A lot of states are doing it. There's good data to support it. I think it's exactly the kind of bill that Chairman Marsico was asking for. The Senate has passed out Senate Bill 501 in the domestic violence context unanimously. I don't know about other areas, but it's rare that a firearms and domestic violence related bill passed unanimously from this body. So what that does is it requires surrender of firearms when permanent protection from abuse orders are issued. Now, we all know that under federal law, if you have final protection from abuse order, you're not supposed to be able to buy a firearm. But there is no good procedure in place for making sure, if a judge hasn't ordered it, that you don't have access to a firearm in your home already. This closes that loophole. It would also make surrender mandatory, and within 48 hours, not 60 days as we currently have it. It protects victims, and importantly, it protects law enforcement officers who know that the most dangerous time is after an order has been served. I think, although I think Mr. Prince may disagree with me, that most people in this room believe that there are some people who have forfeited their firearms rights, including domestic abusers. This keeps guns away from the hands of people we have already identified as dangerous. We have a background check system in Pennsylvania that's working very well. Unlike many states, it requires background checks for the private sale of handguns, and we're a point of contact state, so we have PICs, which I know is often under attack, but I've also read the testimony every year from the Pennsylvania State Police, who continue to say that they have more records than the NICS database. that they use it for more things, that the Charleston loophole that allowed the shooter at the AME church to get his gun would not have happened here in Pennsylvania. And so I urge you to maintain the PIC system, and I urge you to consider House Bill 1400, which extends background checks to the private sale of long guns. I would also urge you, because I know that this has come up a lot in the wake of the school shootings, to look at ways to make our kids safer that do not involve introducing more guns into our schools. I know that the Senate has passed Senate Bill 383. It was a tightly fought bill. Teachers opposed it, parents opposed it, students opposed it, teachers' unions opposed it, many administrators opposed it. Very few people think that arming non-security personnel in schools, understand, found the same exact thing. So I urge you not to be reactionary and say that is the way to go. We should have more money for our schools. If they want armed officers, school resource officers, or security guards, they should be able to make that decision at the local level. We should look at security assessments. There should be funding to do that. But we also need to look at how do we keep guns from the hands of those people that we've identified are likely to harm themselves or others. One way we also know, and it was alluded to earlier, often these children or young people who shoot up their schools got the guns at home. Do we have child access prevention laws? Are adults being held accountable? Do adults who know that the children in their lives are in crisis have an obligation to temporarily remove those guns? We need to look at the adults as well. In the last 5 years that I've worked at Ceasefire PA, I think I've been invited twice to testify before this committee. Once was July of 2013, following Sandy Hook. I sat with Francine Wheeler and Nicole Hockley, who are two parents who lost their children there. There wasn't a dry eye here. Since that time, this House and Senate have passed mandatory minimum bills. You've passed preemption to allow gun groups to sue cities to try and do their own things. You have instruments which we know do not deter further actions, but are about punitive, and people have varying views on those. I think it's time for you to take action on some of these bills. I could have come here and said, we need license and registration, we need to ban assault weapons, we need to ban high-capacity magazines, we need to do all those things. Instead, I talked to you about bipartisan bills, compromise bills that I think we can work on with gun owners, with those who would protect gun rights, and get something done to save lives in Pennsylvania. It has been 5 years. I was on leave of absence. I was supposed to not be working this week. After Friday in Santa Fe, I was so angry, I demanded that I would testify. I came back on the payroll to do this. You have the opportunity. Right after Sandy Hook, I met Mrs. Casey, and she told me that she said to the senator, you're one of 100 people who can do something. You're 27 people out of 203 who can do something, and I urge you to take a vote, to come together, to find ways to do it, to save lives in Pennsylvania.
Thank you. Questions? Comments? Representative Barber.
Thank you for your testimony. The one thing that I didn't hear when you were suggesting the bills that we could vote on a bipartisan basis was in the school context. What should we be doing to identify mental health illness as a possible start? Because what we have heard from our prior testimony was that there are HIPAA requirements that are interfering with that. That's a federal issue. We can't waive HIPAA at the state level. What is it that we can do to make a short-term benefit to public school safety on the mental illness front?
So thank you. I do want to again point out that those living with mental illness are much more likely to become victims of violence than perpetrators. And I know it often gets conflated that it's a mental illness issue. And especially in these school shootings, there always seems to be somebody who knew something. Somebody had gotten some kind of treatment, or somebody had been identified as a problem but hadn't gotten the treatment. So I think part of it is HIPAA. I think these extreme risk protection order bills, I think the bill as drafted here talks about parents and family members and law enforcement. I know that there are suggestions that guidance counselors be included. I do not know how that impacts the rules of reporting that those people and therapists and licensees are they're already charged with. I think we'd have to look at that, because certainly psychologists and psychiatrists have rules when they are supposed to report, but this might not lead to that level, right, because of the HIPAA rules and the oath of treatment. But I think we should look at those HIPAA rules and opening them up and making sure that people who know something can say something. But there are others besides people bound by those rules who often know things. So that could be parents, that could be teachers who are not still bound by HIPAA, that could be friends, family members, coworkers. Those people don't have the same HIPAA obligations. So I think it's worth looking at, but I also think there are ways that we can look at what other states have done and who they allow as reporters in these extreme risk protection order bills.
Representative Secone?
Thank you, Mr. Chairman. Thank you for your testimony. I encourage everyone that's testifying today, I hope you stay long enough to hear both sides of the arguments, because oftentimes we get the advantage of hearing both sides, but oftentimes I see testifiers leaving and they don't hear the other side, and that's the whole point of this, is so we can hear each other's point of view. And I know we're going to hear testimony, I know it really isn't working, and why we need to either make changes or opt out of that. I also just want to add briefly that I am a teacher. I've stood in front of a classroom now for 2 decades. I'm fully trained in firearms use, used it in law enforcement and in the military, carried a weapon in harm's way. Wouldn't you like a person like me in a classroom to be there to defend people when it's going to take 10, 15 minutes for police to arrive, or you have 3 sheriffs standing outside, as we had that incident, doing nothing, while people inside are being killed? I think it's the option of having teachers armed is a viable option. And it is an option. It could be an option. So I think we need to consider those aspects of it. Thank you.
Thank you, Representative Secone. I appreciate your service as a teacher and as representative, and I know personally from our conversations how trained you are. I have grave concerns about the bills in their current form that do not seem to require ongoing training, safe storage, explain who would be allowed to do that, and I worry about the average math teacher who's teaching my kids who may also have a gun. We've also seen even one of the Parkland teachers who was carrying a gun left his gun unsecured in a public bathroom, and somebody found it and shot, and both of them are, thankfully he was hurt, but both of them are being charged. So I think that there's a lot of danger fraught in there, and although I believe that there are many people who are well-trained, law-abiding gun owners who I probably would feel very safe around, I'm not sure that that includes the vast majority of our teachers.
Representative Dean?
Hosting last month's hearings and today's hearings, and thank you, Sheriff, for your service and your advocacy. I wanted to touch on just 2 things quickly. But before I do that, in terms of arming teachers, that my basic comment there is, regardless of the expertise of Representative Secone, I'm a mom, I'm a grandmom, and I think we ask so much more of our kids in terms of the fear that they have to invest in themselves every day. Do we want to add to that your teachers are armed, they're ready, they have guns, or I don't know where their guns are. We ask so much of our teachers every day, while we don't fully support them. Are we really asking our teachers to now, in addition to making sure you know your area of discipline, whether it's mathematics or science or literature, make sure you go to the gun range and be ready to shoot up a class?
The police for a wall check on their son. They didn't have enough evidence to take him into custody or to commit him, and a few weeks later he did commit that shooting. This would have been a different procedure that those parents could have and temporarily removed his firearms. The third question about what do we do about everyday shootings. We have a lot of guns. We have loopholes in the system that make it easy to get a gun for people who shouldn't. In 2012, you passed the Brad Fox law that makes punishments for straw purchasers tougher, and I think that's been to good effect, and that's important. I think we should be tracing our crime guns. We should know where they come from. Some of it is done between the ATF and local jurisdictions, but the information isn't shared. So, for example, I'm sure you've heard that the governor of New Jersey has been playing Pennsylvania for all of our crime guns that end up at New Jersey scenes because they are mapping where their guns are traveling. It would be good to know how far are crime guns traveling geographically, how long from the last legal purchase to to the time of crime. How long are they out there? Who is getting them? How are they moving? Are there certain bad dealers? I've asked the governor's office, I've asked the attorney general to do some of that mapping, to get that data public, so that we would have data exactly as the professor suggested, so that we would know where to focus resources and policies.
I have a problem with the red flag bill. There's no due process here for people. The police just walk in. I'm a former law enforcement officer, so police just walk in, take the guy's guns or the woman's, and it's temporary, which is 1 year. So what happens to the guy or the person that they're taking the guns from when they remove his gun? What's the process with that person?
So my understanding, sir, and again, I think Representative Stevens is the author of one of these bills, is the police officers can't just go in and take the guns. There has to be a petition to a court with evidence presented. That may or may not be ex parte. If it's ex parte, it would only be, I think that Representative Stevens' bill is about 10 days. Some of them go as far as 3 weeks. And then both sides would come in and petition for either an extension of the order or a return, a relinquishment of the order and a return of firearms. We do this in the temporary restraining order process when we believe somebody's a danger to themselves or others. I don't think that system is abused any more than there's other false reporting of crimes or accusations made. I think that this is a serious situation that Connecticut has found, has identified people at risk of suicide, has found at risk, when they removed guns, they found people had about 7 guns in their home, and it has prevented some suicide attempts. I would ask Representative Stevens if he wants to comment on the other due process protections. And I think, unlike many of the other bills, I'll just add that Representative Stevens has a provision for a public defender, so somebody would be represented free of charge.
Representative Stevens, do you want to explain your bill?
Sure. Thank you, Mr. Chairman. As Sharon indicated, the bill has a number of due process protections built in, but she's exactly right in that the police are not going to make this decision unilaterally. A law enforcement member or family member would need to petition a judge, provide information indicating that an individual is a threat to themselves or others, and only upon reviewing that information would a judge be able to issue an order to temporarily force someone to surrender their guns. And then they'll get a full hearing. And we actually, in the bill, and certainly there's an opportunity for amendments, and we're going to be, we've heard a lot of feedback, and we are making some changes to the bill as it's currently written to incorporate many of the thoughts and really careful considerations that many groups have provided. But one of the things that we are working to do is, we were aware that there were some concerns that if an individual was the subject of one of these orders, if a hearing, we wanted to provide a quick hearing, and so we do put a pretty short time frame in there where they're guaranteed to have a hearing. And we actually even have in the bill that the hearing can't be continued without their consent, because there was a concern that the respondent might not have ample opportunity to go ahead if they wanted to have a psychiatric evaluation or present evidence or gather witnesses, things like that. And so we really tilted the landscape in terms of these rights, in terms of the timing, towards the respondent, and gave them more authority in the timing of that ultimate hearing. And at that hearing, again, they have the right to counsel. Unlike many other states, I actually included in the bill that the public defender's office would represent this individual if they could not afford an attorney. The petitioner also has the right to counsel, and the district attorney's office would have the option of helping out in that regard. My thought there was that I wanted both people to have the opportunity to have legal representation, participate in the proceedings on their behalf. Again, both the petitioner and the respondent. They certainly are going to be given the opportunity to cross-examine witnesses, present any evidence they would like, and then obviously the judge would make a determination. And that order then to surrender their guns would last for no more than a year. Again, this is a temporary provision to address a temporary condition. And, when I compare and contrast that with the current 302 process, which is really devoid of any due process protections, we try to make sure that we built into this bill
as much due process as we could really possibly fit into the bill. If anybody has other suggestions for additional due process, protections or provisions, we're happy to incorporate them. But when you look at the current 302 provision, which again acts as a bar for life, with almost no due process protections, this has significant due process protections, and at most would deprive you of guns for a year.
So nobody really answered my question. The question was, if you take these weapons from a person, what do you do with the person? Is there anything in the bill that says the person has to go to a doctor? Anything that treats this person? You're going to take his weapons for a year. You just going to let him hang out there to go buy one somewhere else?
Well, I'm sorry, I misunderstood the question. My understanding is that you're not just taking their weapons, but they would be on a prohibited purchaser list for that time period, so in picks and mix. And the evidence showed a lot of those people get into treatment voluntarily. They do get help that they needed. Some of them were never identified to the system before. I think that is in part up to, I don't think the judge makes that order, but I believe it's the family has the ability and more flexibility to help deal with their family member.
If I could just jump in there, one of the things that Shira pointed out was the significant data about the short time frame in which people make the decision to take their own life. And this bill is really mostly about suicide. I mean, 2/3 of all gun deaths are suicides. And so the idea is you give folks a little bit of time and space, and then they can go get the help that they need in order to address their situation. So they can go see a psychologist, they can go see a psychiatrist, they can go, obtain the services that are crucial for them, and they no longer have the ability to make that impulsive and irreversible decision to take their own life with that firearm. And that's really the key.
So the other question I have with that is, what's the process then after a year?
So we were also mindful of that, and when we were developing the bill, one of the things that someone from the gun rights advocacy side of the equation had presented to me was all too often it's too difficult for folks to get their firearms back. And so we wanted to make it an automatic process. Upon the expiration, it's not like you have to then file another petition to get your firearms back or anything else like that. You would simply go to the agency, you had your weapons. They would have to run a criminal history, run a background check before you get your firearm back. But it would be done automatically without the need for any additional legal proceedings or anything else like that. We were mindful of that, and if you or anyone else have any suggestions on how we can streamline that process, we're happy to consider them and incorporate them into the bill.
Yeah, I know when I was the sheriff of the county, every time we collected somebody's weapons, they had to get court orders. It turned out to cost more for attorneys than the weapons were worth. They must have a lot of them. And it just was a big roadblock in them getting their weapons back. The second thing I wanted to talk about real briefly is I have to agree with you on the PIC system. The PIC system in Pennsylvania is working. There's a lot of flaws with the federal system. I know the federal system wants Pennsylvania to be the point of contact. PIC system checks approximately 14 databases. The feds do not. But what I'm finding out is I've heard a lot of discussion about every time there's a gun show or a major gun event, that the PICS is out of service, they're down. Well, last year the PICS was only down 67 hours. They weren't down every weekend, what people are telling me. And I do like the 15-day yes or no answer rather than a 3-day federal answer, which means that they don't get an answer, they give you the approval, and then if they find out maybe you shouldn't have a gun, who goes and gets it? The law enforcement officer has to now go after some bad guy, and that's a risk. And I would rather be sure, one way or the other, that they have it. So in my opinion, the PIC system is working, and I think that should never go away. Thank you.
Thank you, sir. And since I'm a lawyer by training, I know when the judge agrees with something we said, I say thank you.
Well, thank you, Sheriff. Appreciate your time and your testimony. Troy,
Make everybody else
the next
talk.
testifiers I want to recognize Richard Griggs and present the lawyer right here. Next testifier is Joshua Prince, Esquire, Firearms Industry Consulting Group, and also Adam Kraut, Esquire, Firearms Industry Consulting Group. Good morning, gentlemen.
Good morning. Mr. Chairman, honorable members of the committee,
I appreciate the opportunity to be here today to discuss these important issues along with my colleague, Attorney Adam Kraut. I'm a licensed member in good standing of the Pennsylvania and Maryland Bar and admitted to numerous courts, including the Pennsylvania Supreme Court, the U.S. Supreme Court, the U.S. Court of Appeals for the 3rd and 6th Circuit Courts, and the District Courts for the Eastern, Middle, and Western of Pennsylvania. As my curriculum vitae is beyond the scope of my testimony today, I have attached it as Exhibit A to my testimony. Due to the extensive nature of these bills pending, the voluminous constitutional and legal issues with them, and the extremely limited amount of time that we have been provided to address these issues here today, attached to my testimony as Exhibit H is a review of each bill and the constitutional and legal issues that relate thereto. As there are a plethora of unconstitutional provisions pursuant to the United States and Pennsylvania constitutions in the pending bills, I believe it necessary to start by reciting the oath that every member of the General Assembly is required to affirm pursuant to Article 6, Section 3. And I quote, "I do solemnly swear or affirm that I will support, obey, and defend the Constitution of the United States and the Constitution of this Commonwealth, and that I will discharge the duties of my office with fidelity." Article 6, Section 3 then goes on to declare that, quote, "Any person refusing to take the oath or affirmation shall forfeit his office." Yet we see numerous bills being offered with no consideration for the lack of due process, takings without just compensation, and unconstitutional delegations of authority, let alone the right to keep and bear arms, all of which are made inviolate by Article 1, Section 25. Let me emphasize that. All of those rights are made inviolate by Article 1, Section 25 of the Pennsylvania Constitution as ratified by the citizens of this Commonwealth. Worse yet, we see Governor Wolf and Republican members of the General Assembly discriminating against those with closely held religious beliefs, such as the Amish, by seeking to preclude their ability to purchase firearms and ammunition through proposals such as House Bills 1400, 2249, and 2251. Instead of seeking to restrict law-abiding individuals' rights, why isn't the General Assembly proposing and considering true common sense proposals? Why haven't we enacted a law that further codifies the right of school personnel to possess firearms, electronic incapacitation devices, and non-lethal weapons in assuring the protection of our children, like Israel has done since its inception? Professor Eric Dietz of Purdue University, whose Homeland Defense Institute examined school shootings and compiled a report, determined that armed staff and personnel are essential to mitigate the dangers of an active shooter. While Senate Bill 383 was a decent attempt, it suffers from major flaws, which is why I have drafted an amendment to it that would address all the concerns while ensuring the confidentiality of those school personnel who are armed. A copy is attached as Exhibit B. Why hasn't this committee taken action on Senate Bill 5, which has been pending in this committee since April 26th of 2017, when municipalities are flagrantly violating state preemption, which constitutes a misdemeanor of the first degree? How can this committee condone these acts and not take action, especially when 7 individuals were prosecuted under an unlawful ordinance of the city of Erie, and as a result, incurred thousands of dollars of legal fees with no right to reimbursement? Why haven't we enacted a law that requires notification by the Pennsylvania State Police when a person becomes prohibited from purchasing and possessing firearms and ammunition under state or federal law? If our goal is to ensure that prohibited individuals are not even attempting to obtain firearms and ammunition, I cannot fathom how, regardless of political affiliation, the members of the General Assembly cannot pass such a common sense proposal. For this reason, I have drafted a proposed bill that is attached as Exhibit C. Why haven't we revised Section 6105F to come into compliance with the Nixon Improvement Amendments Act in relation to mental health commitments, where Pennsylvania would be entitled to millions of dollars in federal funds for our compliance? A draft proposal is attached as Exhibit D. Why haven't we amended Section 6105.1 to provide for relief from disabilities for misdemeanor offenses, especially in light of the Third Circuit's en banc decision in Bindrup versus Attorney General of the United States, where the court held that such prohibitions can violate an individual's Second Amendment rights? A draft proposal is attached as Exhibit E. Why haven't we provided the Pennsylvania State Police with the authority to issue legal determinations under the Uniform Firearms Act, like we have in relation to the Liquor Control Board laws, so that individuals can ensure their compliance with the law? A draft proposal is attached as Exhibit F. If you want to talk about bills that actually protect the public and law-abiding citizens, then these are the bills we should be discussing. More importantly, if you believe individuals who have been adjudicated incompetent, committed to a mental institution, or convicted of a crime punishable by more than 1 year are such a threat to our society to warrant deprivation of a constitutional right in perpetuity, why haven't you proposed a law that would likewise prohibit those same individuals from being able to vote or from becoming reporters or members of the General Assembly? We have youth that believe eating Tide Pods is an acceptable and safe after-school activity, and a small number of people knowingly break the law to commit crime, yet we're here discussing proposals on how to further restrict law-abiding citizens' constitutional rights rather than address the underlying issues. In closing, an attack on the right to keep and bear arms of law-abiding citizens is an attack on our republic and our founding constitutional agreement. As written by Thomas Jefferson, the laws that forbid the carrying of arms are laws of such a nature. They disarm only those who are neither inclined nor committed to commit crimes. Such laws make things worse for the assaulted and better for the assailants. They serve rather to encourage than to prevent homicide, for an unarmed man may be attacked with greater confidence than an armed man. Thank you, Mr. Chairman, and members of the committee for the opportunity to testify before you today. I will now turn it over to Attorney Crouch.
Good morning, Mr. Chairman, honorable members of the committee. When these hearings were first initially announced, I was quite frankly a little disappointed to see bill included House members. However, I am grateful to be here, and I am glad you extended the opportunity to allow public testimony on the matter here. I, like my colleague, Mr. Prince, I'm a licensed member in good standing of a variety of courts, including Pennsylvania Supreme Court, as well as numerous federal courts. I won't bore you with those details. A copy of my curriculum is also in Exhibit A. While in law school through October of last year, I was also the general manager of the gun store. So I see this debate from a variety of perspectives, both as a lawyer, having had time behind the counter. During my 3 years behind the counter there, I interacted with people from all walks of life, law enforcement officials, as well as ATF. My experience allows me to see the gun debate from a variety of perspectives. That includes first-time gun buyers, somebody who's never owned a gun before, coming in for whatever that reason may be, to the law enforcement official who's coming in on official business. It seems that there's a fundamental misunderstanding that many members of the General Assembly and the public have when it comes to firearms and firearms rights. The right to keep and bear arms is not granted by the federal or state constitutions. It's a pre-existing national right, and that recording of which can be traced back to 13th century England in the Magna Carta. The purpose of the Second Amendment in Article 1, Section 21 is to ensure that the government doesn't infringe upon this pre-existing right. While the Second Amendment is often quoted and debated as to its meaning, and some people like to believe that there is no individual right, even though the United States Supreme Court has said otherwise, Article 1, Section 21 makes it explicitly clear. The right of the citizens to bear arms in defense of themselves and the state shall not be questioned. Looking through the bills that are in front of this committee, it would appear that a number of them violate our state constitution. For example, SB 17 seeks to deny citizens the right to assault weapons in high-capacity magazines, all while violating a number of constitutional provisions, including due process and the takings clauses. And let's be clear here, the term assault weapon is a term of art that has been concocted in an attempt to confuse the public garner support for the banning of a particular class of firearms.
Just so you know, these ladies in the red are Mom Kinetic Action. There's a whole bunch of them.
In addition to constitutional concerns, SB 17 will also deny people, especially those who are disabled or of limited size or skill, the ability to adequately defend themselves within their own homes. For some reason, the magic number with legislators is 10. No one needs more than 10 rounds to defend themselves is one of the hallmark battle cries of those seeking to fight restrictions. Yet, there's plenty of reasons a person may need more than 10 rounds. We continue to see home invasions where there's multiple intruders. There are plenty of incidents that have been reported in the news, such as the woman down in Georgia who had 3 individuals break into her home at 4 a.m. All 3 of those individuals were armed. Perhaps the gentleman in Oklahoma who defended his home against 3 intruders during a home invasion with an AR-15 may make an interesting case study. Let's not forget the heroic 15-year-old who defended his 12-year-old sister in Texas with an AR-15 against 2 intruders. And then, maybe we should ask the woman who shot an intruder 5 times and did not fully incapacitate him. What if she had a gun that was limited to 10 rounds against multiple intruders? Would 10 have been enough for her? The practice of law has led me to see the gun debate through an even broader lens. I've had to inform countless clients that they're no longer able to own a firearm because of some non-violent offense they committed decades ago. I've also had to advise individuals they'd likely be prosecuted for making purported false statements on the forms required to purchase a firearm, all because they were never informed that at any point by pleading guilty to an offense, they would lose their right to keep and bear arms. It seems that a number of attorneys, district attorneys, and even judges don't have any idea as to what offenses lead to the prohibition of somebody. Whereas yet, the guilty plea colloquies don't inform people that they're actually going to lose their rights. And perhaps even more egregious, their options for relief are often limited, expensive, and offer no guarantee for the restoration of that right. Being stuck in such a position limits the ability of a person to choose a firearm for self-defense. Now, we've heard a lot of testimony this morning already, and I think there's one thing that we can probably all agree on in this room, regardless of where we sit on the gun issue, and that's the protection of our children. If that's the case, then why are we not doing things like allowing teachers and administrative staff and school resource officers to be armed who wish to do so? I'm not saying we should mandate it, because I understand that people may not be comfortable with that. Why are we not making schools hardened facilities? Is this just merely because it requires an answer we don't like, even though it may be the best answer? And why are we not teaching firearms education in schools anymore? We teach our children about sex, teach our children about drugs, because we as adults understand that kids are going to engage in those activities, whether we want them to or not. But we give them the skills and the tools to make informed decisions about that. Why are we not teaching kids how to handle guns safely, so if they find themselves in a situation where one is, they have the skills and knowledge set to act appropriately and leave the situation safely? Before this committee stands a plethora of bills that have been drafted in an attempt to say we did something. It's come at a time when emotions are high, and understandably so. However, this committee and the General Assembly should not advance legislation based merely on emotion. It should be passed after careful debate based on logic and reasoning. These are kind of outside my prepared remarks here, but I did want to touch on culture of responsibility. And that seems to be something that is lost as a whole within our society, and I don't think that's anything that you can legislate back into. I think that's going to have to start in the homes, and I think we as parents, as family members, we need to start instilling that into our communities, our families. Mrs. Goodman had mentioned straw purchasing. I was at a NICS conference at FBI's headquarters last summer, I believe it was. FBI prosecutes, or the U.S. attorneys prosecute approximately 1% of straw purchases across the board. 1%. It's illegal. There's a law against it. They don't get prosecuted. We had an incident where there was a state trooper in the store. There was an individual who turned out to be prohibited. Let the trooper know, and the trooper kind of shrugged his shoulders and out the door he went. PICs being down at gun shows, I heard that was mentioned. I worked at a gun show. I was trucked 2.5 hours. I'd say at least 25 times before I was able to get it. There are some issues with PICs. I'll let Mr. Stolper, I'm sure, is going to expand on that. But having experienced it, I just did want to let you know that there are some issues with PICs. And Representative Stevens, your bill, you mentioned that there would be the automatic return of firearms upon the expiration. part of the issue to some degree, I have other issues with your bill, but I don't know if you're aware. Part of the issue would be just the NICS being updated as to the person no longer being prohibited. That's not an instant process. So, you know, if you told me today my order was up and I went to go get my stuff back, it's likely I would get denied. So.
Well, along those lines, I'd love to sit with you and come up with a solution to address that. Maybe it's submitting the information, you know, in advance of the expiration of the order so that there's an opportunity for that to be entered or some other solution. But I'm happy to work with you to try to ensure that those folks, upon the expiration of that order, are able to, you know, obtain their firearms again.
Okay, I just wanted to make you aware of that. And I'll just leave you with this thought. The laws you make are only going to be as good as the willingness of people to obey them. Thank you.
Thank you, gentlemen. Members, please make sure the microphones are turned off when you're not speaking. So, Attorney Prince, you had mentioned in your comments and your written testimony about Senate Bill 5.
Some moms demand action, see?
I am.
So where's the Second Amendment people?
Really? You mentioned that we did pass that bill out of the committee twice, last session and this session. It's sitting in the Senate. In fact, that bill was in the Senate before Senate Bill 5 was even introduced.
And House Bill 671 does not provide all the protections that Senate Bill 5 does, and it is not consistent with what was previously passed and held unconstitutional by the Pennsylvania Supreme Court, not because of the context of the legislation, but the way in which it was added to a copper bill. The protections by House Bill 671 are not sufficient. Senate Bill 5 does provide the requisite protections, and I do address it in my Exhibit H, where I review both bills together.
Didn't realize that, but you only mentioned Senate Bill 5.
Correct, because I believe that's the only true answer currently pending before the General Assembly.
That's your opinion.
Yeah, that's what I said.
Okay. Thanks. Representative Dean for question.
Thank you, Mr. Chairman, and gentlemen, thanks for being here today and participating. A couple of things. Number one, you are part of a consulting firm and you bill yourself as a firearms industry consulting group. Is that correct?
That is correct.
Okay, firearms industry consulting group. I want to dispel a myth that you cited, which is that these bills are brought up hastily and in emotion. I'm sure there's deep emotion around this country and in this room about the loss of life in this country from gun violence. But you need to know that these bills have been brought up session after session after session after session, many of them. So this is something that thoughtful legislators on both sides of the aisle have been trying to do for a long time. So my basic question is, what do you want to do to save some lives?
Disarm the Democrats. All those people clapping and moms just demand action.
Well, we can start by looking at what the problems are. It seems like a lot of people like to point to guns as being the issue. We've heard mental health mentioned. Personal responsibility is another one. There's some things that you just can't legislate. You can't legislate the actions of an individual. You can impose penalties on them. We've heard about mandatory minimums, things that are deterrent. That's the point of the law. Some of it's punitive, some of it's from deterrent factors. But as far as what you can
I would
do,
interrupt you and ask you to concretely tell this room that is eagerly awaiting your words. What do you want to do to save lives? You've quoted the Constitution and the constitutional right to bear arms, both in Pennsylvania Constitution and the United States Constitution.
Yes.
Many of us on the other side of this honor the Second Amendment. That's not what this fight is all about. This is actually a fight about saving lives.
Holly needs
What
to
do you want to
get
do
calm.
to protect that other constitutional right, which is the right of life, liberty, and the pursuit of happiness? When our
Come on.
children are not safe walking into their school, when they are slaughtered as babies, when people going to church are no longer racked with poverty, are also fearful of the guns they hear at night. What do you want to do to protect that right? I mean it, specifically, concretely. Are you in favor of background checks? Should we close that loophole here in Pennsylvania?
There is no loophole.
What loophole are you referring to? Are you talking about
The
private
private
party
sale.
Can you point to a single example where a private party
No,
sale?
wait a second.
Oh,
No, the question
may I?
is from me to you, if you don't mind.
Okay, guys, hold on a
Oh,
second.
please.
Like I said earlier
Really?
today, in my introductory remarks, we want to have a civil, professional, respectful dialogue.
Thank you.
And I'm hoping that you listen to that again. And I would rather not have applause either.
Thank you.
I respect, I know this is a very emotional issue, but let's just calm down a little bit, okay?
Mr. Chairman, you're absolutely right, and I apologize. I'll ask you just simply, specifically, concretely, what do you want to do to save lives? Thanks.
Well, ma'am, it sounds like we have a little bit of a societal problem. You point to a couple of different places. You speak about inner cities, you speak about schools, you speak about churches. And we talk about individuals who come that have problems, right? We can start by talking about schools, if you would like. You know, schools currently, most of them, and it's been a while since I've been to a grade school or a high school, so bear with me here. I know when I was in high school, anybody was able to just walk into the school. I know shortly after I left high school, they started to do things like locking the front door at least, and if you were a student, you would get buzzed in, seen with people, and you had to check in with somebody. So depending on the schools, and I don't know all the details, some have systems in place to at least keep people just walking right in. Then the question becomes, do you put armed individuals into the schools, be it teachers, and I know you're not in favor of that proposal. Do you put school resource officers there, retired officers? Do you have a dedicated police officer there? I don't think there's a clear-cut answer as to the best way to do it. We're all going to disagree on that. Churches are certainly free to take up their own security measures, and they do. In fact, Mr. Prince spoke at a seminar, which he can tell you about, where a number of churches in the area came together to talk about security plans for their places of worship. So there are things that can be done that don't necessarily require laws to do it. It requires a community response to look at and evaluate what's going on within the community and how can they fix it. What can they do as far as their own private facilities or the public schools, for instance? It doesn't necessarily require a law. And quite frankly, a law is only as good as the people that follow it.
Then I guess we shouldn't have any laws. There shouldn't be laws against murder. There shouldn't be laws against anything. No laws against theft, because some people simply won't. I want to point out an area of agreement that you and I have, and that is education. Education about handling guns. I utterly agree with you.
Thank you.
And I also agree with you that this might be what we're up to, which is hardening our schools, making our schools more like prisons if we, legislatures, and if the federal government fails to act to protect our families.
Because I do have grave concerns about other potential attacks on our children, but it goes well beyond our schools. It is not just a matter of hardening our schools. There are other related activities that need to be protected, and that is a debate that should happen, but behind closed doors, so that individuals who are likely to carry out those types of atrocious attacks are not informed of those possibilities or ways in which to carry out their terrorism.
Representative Stevens?
Thank you, Mr. Chairman. Thanks again for your testimony. Maybe I missed it. I was going through. I didn't necessarily see my bill addressed in your materials. I could have missed it again. I was reading through pretty quickly. But if you had, some thoughts on ways that we might be able to, or concerns that you had with the bill, I'd certainly be interested to hear them, because I'd like to try to address them if we can.
Sure, I believe the extreme risk protection order review is on page 8 of Exhibit H.
Right, I think, if I remember correctly, those were two other bills. My bill's House Bill 2227. Those were Senate Bill 18 and House Bill 2109. Mine, I think mine's pretty unique in its approach. We tried to, and also, as I mentioned, had some preliminary conversations with some folks on both sides of this issue and tried to incorporate many of their thoughts. So I'm interested to hear
what else we can do.
I believe there's a number of concerns when we look at the constitutional issues, both under the U.S. and Pennsylvania Constitution when it comes to due process. And in fact, that's part of the reason why when we look to federal law, it specifies that a prohibition only results after the individual is provided notice of a hearing, provided a hearing, and an opportunity to be heard. Because we acknowledge that due process mandates that notice and opportunity to be heard before stripping someone, especially of a constitutional
See if I can
right.
get a close-up of his
Also,
name.
there's a grave concern over the process for those ex parte hearings. I understand that your bill
Looks
are
like
low income.
Representative
What about
Madeline
those who are
Dean.
not low income? And quite honestly, in my experience, especially where public defenders are provided under
Representative
Section
Madeline
303
Dean.
of the Mental Health and Procedures Act, I have yet to see a public defender actually defend that individual being subject to those proceedings. Generally, it is a stipulation that, yep, this individual can be involuntarily committed for up to 20 more days. So while I don't want to discredit the public defender's office, and it's not a statement on public defenders across the Commonwealth, there is a concern over the amount of cases they have to handle and their ability to adeptly handle those cases, especially when you're going to be placing these additional obligations on them. As an attorney, I can tell you that to represent an individual in this type of situation, you're potentially looking at thousands of dollars. You mentioned the possibility of going out and getting a psychological evaluation. Generally, that's going to cost $2,000 for an MMPI test that is performed by a psychologist. It's generally going to take 1 to 2 days. That means that anything is performed, all so that that individual can go into a proceeding where there's already been an ex parte order issued against him or her. That is a grave concern when we start to look at the constitutional rights, which again, under the Pennsylvania Constitution, are acknowledged to be inviolate.
Has the court, and this is your area of expertise, has the court opined on the constitutionality of the current ex parte proceeding regarding PFAs and frankly 302s?
They have not, with regard to my knowledge, with regards to ex parte PFAs. They have just recently, the Western District of Pennsylvania, in a case I litigated, Alton Franklin versus Sessions et al., held that because of the lack of due process provided under Section 302 of the Mental Health and Procedures Act, it is not sufficient to trigger a federal prohibition because of the absence of that due process.
And that's only in the Western District. In the Middle District and the Eastern District, the standard of the 302 being alleged that still is in place, even absent those due process protections.
It's my understanding that that's the position of the U.S. government. It's hard to fathom how that is a correct interpretation based on the court's determination that it doesn't meet the requisite due process analyses.
Yeah, I don't disagree with you. I'm not quarreling with that contention that the 302 procedure is devoid of due process that probably should be incorporated when you're talking about a lifetime deprivation of a constitutional right. I can understand that. And frankly, we had that in mind when we were drafting my bill. So I guess if the ex parte provisions regarding the PFA Act have been upheld as constitutional,
they haven't been upheld as constitutional, they haven't been challenged. Then you're talking about tens of thousands of dollars that an individual or entity would have to put forth to actually challenge these types of provisions.
So they haven't, I mean, look, if they haven't been struck down, and they've been in place for many, many years, certainly, you know, thousands and thousands of individuals have been subject to them. I guess I'm trying to understand upon what legal authority, you know, you make that statement that
the Constitution.
No, I get it, and I understand you're entitled to your opinion about what the Constitution says. But as someone who's been elected a judge in the Commonwealth of Pennsylvania, do they happen to agree with your opinion as it relates to that ex parte proceeding?
There's never been a challenge because it's a limited period of time. There's only 10 days for an actual hearing to be held on the underlying PFA. So there is no real opportunity for someone to mount a full-blown challenge because by the point in time the challenge would be determined, it would in essence be moved.
Well, I mean, you could presumably seek to get an injunction to prevent the imposition of that disability. immediately, right? I mean, you have the ability to seek that relief. Do you envision any scenario where an ex parte proceeding could, for the slightest period of time, limit the right to keep and bear arms?
The U.S. Supreme Court has acknowledged that in the absence of a hearing being provided pre-deprivation, there are occasions where a post-deprivation hearing is sufficient. However, it must be held in a very close proximity to the ex parte order, and you must obviously provide the other individual, the person who's being aggrieved by it, the opportunity to be heard and to provide a defense. So I acknowledge the U.S. Supreme Court has even stated that there are occasions, but they have limited those occasions whereby someone can be temporarily denied a even constitutional right, provided that there are mechanisms in place for a timely hearing.
Okay, so if you don't mind, I mean, if you want to get me that site maybe, that would be terrific, and we can try to make sure that we are staying within the confines of that jurisprudence as it relates to the constitutionality, and then that may be one way to address those constitutional concerns that you raised. It seems like that might be the right direction to start looking at what parameters the court has already laid out, right?
The concern is obviously vindictive use of these processes, and I handled a case out in Cambria County where an individual had over 300 firearms taken in relation to an ex parte PFA. When the hearing was held on the final PFA, the judge was so incensed by the lack of any basis for not only a final PFA, but even for the issuance of the ex parte PFA, that he vacated both and ordered the firearms to be returned. However, then the court directed that the respondent, who was found not to have done anything wrong, had to pay the fees of the sheriff's guns, and there were thousands of dollars being assessed against him for having done nothing wrong. Thankfully, we had a judge where, when we addressed the constitutional issues beforehand, said, no, this is wrong, and directed the sheriff to return all the firearms at no cost to the respondent.
Well, one of the provisions in my bill does require, or does provide for penalties for those who would provide false information. And I know, I appreciate your support for mandatory minimum sentences. That's been my bill for the last several sessions. I've also did the bill to increase the penalties for those who are illegally possessing firearms, things along those lines. So I share your feelings in that regard, and I think that would be applicable here. If we provide for some strong penalties for those that would abuse this approach, I think we can deter that type of conduct and ensure that people are not being wrongfully ensnared with, with these provisions. So again, I'm happy to work with you to make sure that there are robust penalties for those that might abuse this approach for some ulterior motive. Happy to work with you in that regard.
I look forward to it.
Thank you.
Within this time segment, we have time for one more question. Representative Cohen.
To save lives, and then one of the comments was that our children are being slaughtered as babies, and we tend to point to the instrument as the problem here, in this case guns, but if you want to use that logic, I say we can ban those abortion scalpels and we'll save 30,000 lives.
Amen. Amen. Yeah.
So what we can do, though, do you agree, is have threat assessments for all of our schools, because every school is different. There's no cookie cutter solution to our schools being hardened one way or another. Some schools have certain techniques they've already applied. Some might not need them. We need to look at each school independently and see what the threat is and what techniques we need to make that school safer.
Absolutely. I completely agree that we need those threat assessments. I believe there are organizations, I believe one is in attendance today, Rockwell Tactical, that has experience doing it, not just for schools, but also for churches and other court facilities. They've done some phenomenal work with, I believe, the Chester County Courthouse. So there are those organizations that stand ready here in the Commonwealth already to provide those threat assessments for schools. And I know there was a comment made about the recent shooting and the fact that the school was hardened there. I'm not so sure how hardened it was when we had an individual able to walk in with those firearms without being checked. Why aren't we going to clear backpacks? Why aren't we having metal detectors in the schools? Why aren't we taking those precautions to prevent these types of attacks, as well as having armed either teachers or resource officers that are available to respond to situations? As I said in my testimony, Israel has been doing it since its inception and has been doing it very well. We could take some great advice from Israel and how they have ensured that there aren't these types of atrocious attacks in Israel, and we know that in Israel they're under constant attack.
The NRA also does have a program that's provided free to schools who want to utilize it for exactly that kind of assessment as well. So that is another option. Obviously, it's up to the school to seek it out, but options do exist.
Thank you, gentlemen, for your time and your testimony. I'd like to recognize Ms. Schemmel, who's so next to testify is Mary Beth Stanton Christensen, Moms Demand Action. And also
Holly
Sarah
is tuning out. She
Higginbotham,
can't stand this right
every
now.
channel for gun
Moms
safety.
demand
Welcome.
action. They're all here. You should see everybody. They're the one who claps and yells. Go. Just go.
Good morning.
Should be by 11.
I am Mary Beth Christensen. I'm a volunteer for Moms Demand Action for Gun Sense in America. Moms is an all-volunteer organization. We are nonpartisan, we are single issue, we are grassroots, we are dedicated to ending the epidemic of gun violence in America. With close to 5 million members across the country and 14 active chapters in Pennsylvania, we are the largest gun violence prevention organization in the United States. And I am the volunteer state legislative lead for Moms Demand. I am also a responsible gunner. I want to thank Ron Marsico for these 7 hearing days on firearms and public safety. I've seen throughout the 7 hearing days, and it's been confirmed again today, that any discussion of the right to bear arms and the right to be safe is a hot button one. Common ground and joint solutions often get lost in heated rhetoric and emotion. So Chairman Marsico, I sincerely thank you for scheduling these hearings and letting all points of view to be heard. And I know that we can find common ground. I've lived on both sides of this debate, guns. My only experience with guns was an armed home invasion of my godmother and 2 armed robberies of my uncle's corner grocery in South Philadelphia. I moved to college in Washington, D.C. I was educated at Catholic U on the Brookland campus. It was a site of frequent shootings, and for 4 years I lived in a room, first floor, with bars on my windows. We had a sexual assault on my floor junior year, and D.C. cops in my lobby for the 4 semesters after that. But then I left D.C. and moved to Carlisle for law school, and I married into a very large, very extended family of central Pennsylvania hunters. I came to understand and respect and eventually enjoy the sportsman's tradition, and my husband and I raised our 3 adult children as responsible gun owners. So I've lived this issue, and one thing I know for certain is that Second Amendment advocates and gun safety advocates have more in common than we can admit, and certainly more in common than we get credit for. And that brings me to the work of Pennsylvania Moms and the domestic violence protection bills, which are pending before this committee. Your former colleague, Tom Killian, introduced SB 501 a year and a half ago in the Senate. And 2 months ago, yesterday, that bill was unanimously passed by the Senate. It's before the committee now. Shortly thereafter, your colleague, Marguerite Quinn, introduced HB 2060, which pretty much mirrors SB 501. It needs some of the later amendments that we negotiated with the gun lobby. But that too is before your committee. And I'm going to just refer to the bill as 501. It's a bill that quickly disarms convicted domestic abusers and safely secures their weapons. What it requires is that within 24 hours of a criminal conviction for misdemeanor domestic violence, or within 48 hours of being placed under a final protection from abuse order, the abuser turns over his firearms to law enforcement, to a federally licensed gun dealer, or in the case of a final PFA, to a designated attorney. Importantly, SB 501 does not apply to those who are simply accused of domestic violence. It applies only after abusers have had their full day in court, have exercised their constitutional right to due process, and the court has found the abuser to be guilty of the crime of domestic violence, or to be so dangerous that he must be placed under a final protection from abuse order. It's not the gun, it's the person. And here, this is a person who has been adjudicated a domestic abuser and is prohibited from holding a gun. So Pennsylvania Moms for the last year has worked closely with the Pennsylvania Commission Against Domestic Violence to pass this critically needed bill. It's endorsed by the state police chiefs, the state sheriffs, and the state district attorneys associations. It's not an exaggeration for me to say to this committee, time is of the essence to pass SB 501. Why the urgency? Because domestic violence in America is to a significant degree a problem of gun violence. Every year in this country, there are over 5 million incidents of intimate partner violence. And we know that when a gun is present in these incidents, the victim is 5 times more likely to be killed. In an average month in our country, 50 women are shot to death by an intimate partner. We know that domestic abusers use guns to control their victim, even if they never pull the trigger. Threatened with a gun by an intimate partner. And we know all too well that domestic violence drives the majority of mass shootings in this country. Nearly 60% of mass shooting former spouse, an intimate partner, or a family member. And Pennsylvania reflects these national statistics. In the last 10 years, 1,600 Pennsylvanians died from domestic violence. In 2016 alone, just over 100 Pennsylvanians were murdered in domestic violence incidents. The majority of them were shot. 2 of the victims were our law enforcers.
Here you go.
So yes, time is of the... I want to depart from my remarks to reference the appendix that the prior speakers submitted. On page 25 of Mr. Prince and Mr. Kraut's submission to the committee, paragraph 2, the attorneys state, House Bill 2060 and Senate Bill 501 are substantially similar and seek to require individuals who become prohibited due to a domestic violence conviction or protection from abuse order to turn in their firearms and ammunition. This is the important part. Even though 18 U.S.C. section 922 sub G8 and sub G9 already preclude those subject to a protection from abuse order or domestic violence conviction from possessing firearms or ammunition. That is accurate. It's completely incomplete. As these 2 Pennsylvania attorneys well know, Pennsylvania has never complied with federal law. For over 20 years, since the Lautenberg amendments were added to the Brady law, abusers under final protection from abuse order or who have been convicted of a misdemeanor domestic violence crime are prohibited from holding guns. But that hasn't been the case in Pennsylvania. In Pennsylvania, if you're currently convicted or placed under a final protection from abuse order, you need not surrender your guns. That requires a separate order by the judge. And that happens in only 1 of 7 cases. If you are convicted of the crime of misdemeanor domestic violence, Pennsylvania does require you to hand over your guns. But we currently give the abuser a 60-day grace period before he needs to turn over his guns. And incredibly, in Pennsylvania, when these abusers finally do turn over their guns, it's the abuser's decision who gets to hold that gun or guns for safekeeping, not the judge, not the prosecutor, and certainly not the victim. It's the abuser's choice. Now, turning back to page 25 of Mr. Kraut and Mr. Prince's testimony, they state that we have been, quote, unable to show a single occasion where an individual gained access to firearms from third-party safekeepers. So I will give you two examples. They asked for one, I'll give you two. In early 2011, Tina Souders, a 39-year-old mom of two boys and a nurse, right, final protection from abuse order from the Fulton County Court of Common Pleas. The court placed the boyfriend under the final protection from abuse order. It granted Tina's request and told the boyfriend to turn in his firearms. He did, as was the boyfriend's right in 2011, and as is a boyfriend or abusive partner's right today. He decided who would get the firearms, and he gave them to his sister, who promptly returned them for the murder of Tina Souders. That's example number one. Example number two, 2 years old, shot in the back by his father. Sorry. We know the family, so we get a little emotional. Michael was a toddler from Huntington County. In 2013, his mom, Holly, went to the Huntington County Court of Common Pleas and asked that the abusive dad be placed under a final protection from abuse order. She also asked that his extensive collection of weapons be turned in, and that request was denied. When it was denied, his parents, the abuser's parents, stepped in and took the weapons for safekeeping because they were afraid of what might happen.
Here I go again. Thank you.
Within a month, Mom in her face and three times rather, in her legs. Mom survived, Michael did not. That's example number two. So I would say to Mr. Prince and Mr. Kraut and to all of us, shame on us. We don't know whether Michael and Tina would be alive today had Pennsylvania law been in compliance with long-standing federal law. But what we do know is that the list of victims will continue to grow unless we follow federal law and pass SB 501 and quickly disarm convicted domestic abusers. And when I say the list of victims, I include law enforcement on that list. I'm sure you know, Representative Krasviak, that responses to domestic violence calls are the most dangerous response for first responders. More officers are killed responding to domestic violence calls than any other call for service. And in 2016, 2 Pennsylvania law enforcers paid the ultimate price. Cannonsburg police officer Scott Bashoon, a 52-year-old Air Force veteran, a dad of 4, and a devoted husband, was murdered responding to a domestic abuse call on November 10th. The following month, on December 30th, 2016, Pennsylvania State Trooper Landon Weaver of the Bedford Station was also murdered by gun, responding to a domestic violence call. He was just 23 years old and recently married. So Pennsylvania Moms urges this committee and the full House to honor these victims, to act on the endorsement of the state police chiefs, sheriffs, and district attorneys association, and to follow the unanimous action of our Senate. Chairman Marsico, this is the common ground that you referenced in your introduction. Thank you. And now I'll introduce my colleague from Everytown, Sarah Higginbotham, who would like to address ERPO.
Thank you, Chair Marsico, committee members, for the opportunity to testify today. Obviously, we've submitted substantial written testimony, so I'm going to try and highlight here the high points. I know you have a long list this morning, and we deeply appreciate all of your time in hearing testimony on the critical issue of gun violence prevention. My name is Sarah Higginbotham, and I am a regional director of state affairs with Everytown for Gun Safety, and here also on behalf of the Pennsylvania chapter of Moms Demand Action, organization in the country, and the Pennsylvania chapter of Moms Demand Action represents tens of thousands of Pennsylvanians around the state, including 14 local chapters. You already heard from Shira from Ceasefire PA about some of the suicide statistics here, so I'm not going to repeat all of them, but I will just highlight a few. In an average year, nearly 1,500 Pennsylvanians are shot and killed with a firearm, and between 2012 and 2016, suicide by gun accounted for 62% of all firearm fatalities in this state. You've already heard about our avid support over the last 3.5 years on domestic violence legislation. And we certainly urge your red flag legislation, also known as ERPO, introduced by Representative Stevens, House Bill 2227, is another critically important policy. Right now, when family or law enforcement see warning signs that someone is likely to pose a risk of harming themselves or others, there are certain ways that they can take action. But when it comes to restricting a person's access to firearms, they are too often powerless to act. You've heard a few examples that Shira also mentioned earlier, and in my written testimony, you'll find both research on the number of mass shootings that we studied where there were warning signs flagged, and then you've also heard some of the higher profile instances, the Parkland shooter, the Isla Vista shooting. Like federal law, Pennsylvania currently does prohibit gun possession by certain people, including those who have been convicted of serious crimes, adjudicated mentally ill, or committed to a psychiatric hospital, or who are subject to a domestic violence restraining order. However, if a person shows warning signs that they are likely to use guns to harm themselves or others, and they do not fall into one of those prohibited categories, they will still be able to purchase and possess guns. Red flag laws like House Bill 2227 can save lives by empowering family members, and that's really key, and law enforcement to act when they see these warning signs. I'm just skipping ahead because I know you've heard a fair amount of this already. In short, by getting a new type of court order, usually referred to, as you've heard, as an extreme risk protection order, red flag laws establish a fair process by which courts can temporarily restrict a person's access to firearms, as Representative Stevens has explained. That process is modeled after the process for obtaining domestic violence restraining orders, which are currently available in all 50 states, and allow courts to determine whether a person is likely to harm themselves or others with a firearm if they are to prohibit them from purchasing and possessing firearms and order them to surrender any firearms in their possession while the order remains in effect. There are two sections, also in my testimony, one again on shooting and the other on gun suicide, and I want to come back to that again. In the aftermath of the Parkland shooting, which received so much national attention, these laws, and I work in more states than just Pennsylvania, though Pennsylvania is my favorite, and I appreciate again the opportunity to be here. We have seen these bills get on these red flag laws and legislation get unprecedented support by both parties, and in large measure by Republicans around the country. I want to come back, while the conversation has been largely on mass shootings, to the problem of suicide. The country, and I just will underscore quickly one thing that Shira Goodman mentioned earlier today, because it is so important. Guns are used in over half of all suicide deaths, and that's important to note. Those numbers are high for a simple reason. Because guns are more lethal than almost any other method of self-harm, and people who attempt suicide with a gun are overwhelmingly likely to die. Simply put, reducing a suicidal person's access to guns can save their life. 9 out of 10 suicide attempts with a gun result in death. By contrast, most people who attempt suicide by other means survive, and they do not eventually die by suicide. This Connecticut study, which again Shira mentioned, but and I'm happy to provide to the committee, we can actually submit a copy, but we will do so. Just highlight the number. The ERPO law, the red flag law, that's been there for a number of years and was the first state to pass it. The Duke study estimated that the law had already averted 72 suicides. And in addition, and this gets to something that was brought up earlier about what are we doing to get these people help when it comes to mental health or resources they may need. In addition, the study found that nearly half of the gun removal cases in Connecticut led to people receiving mental health treatment they might not have otherwise received. So that's a really critical part, and this can be a gateway to connecting people with the resources that they might need to get help. In short, red flag laws can provide a lifeline for people in crisis and for their families, helping to avert suicides and get help to those who need it. Quickly, you have the bill sponsor here, and again, we thank Representative Stevens for his dedication and his work on this. And I just want to highlight very quickly and then wrap up a few of the policy elements. We take respect to the Second Amendment very, very seriously at every town and at MOMS, and look at every piece of legislation before we support it to make sure that it does respect the Second Amendment and that the rights of law-abiding gun owners are being given due attention, rightfully so. So we believe that Representative Stevens' bill ensures appropriate due process and appropriate standards. Let me just highlight a few points. Final orders can only be issued after a full hearing is held, at which all parties have an opportunity to be heard. Temporary ex parte orders can be issued before a hearing, but only if the danger is imminent. These orders only last for a short period of time, as you've heard, no more than 10 days, at which point a hearing must be held before a final order is issued. Here's what House Bill 2227 will do. It will establish clear standards for who may petition the court to issue an order, what evidence must be presented in support of such petitions, and what factors the court must consider when deciding a petition. Number two, it will establish appropriate burdens of proof. That's important. For the petitioner must meet to justify the issuance of either a temporary or a final order. Number three, in addition to ensuring all parties an opportunity to be heard before final order issued, House Bill 2227 also affords those who are made subject to final orders an opportunity to request that the court terminate the order once it's issued, if they can demonstrate that they no longer pose a threat. And finally, if an order expires and is not renewed, the firearms prohibitions are lifted and they can retrieve their firearms, as has been discussed here today, as long as they're not otherwise legally prohibited from having them, which happens when the background check place. Just a note around the bipartisan support and the wave of legislation around red flag laws that we've seen. Republicans and Democrats in at least 29 states right now, your colleagues in state legislatures around the country, are considering these bills. 8 states now have red flag laws. In the years since Connecticut and Indiana passed precursor laws, red flag laws have been enacted in California, Washington on the ballot, and Oregon. And most recently, since the Parkland shooting, Florida, Maryland, and Vermont have all been recently signed by governors. And extra points to anyone who can name, no, I'm not, I'll just tell you, but who can name what those 3 states all have in common. They all have Republican governors and longstanding traditions of responsible gun ownership. So I will leave you with that thought. And again, on behalf of the Pennsylvania chapter of Moms Demand Action, I thank you thank you, Chair Marsko and members of this committee for joining in this conversation. And we urge your swift support of domestic violence legislation and Representative Stevens' bill, House Bill 2227. Thank you.
John, you wave off? Okay. Any questions or comments, members?